welcome everyone. I'm Eric Ramonathan, Executive Director of the Program on the Legal Profession. Thanks for coming today. We're off our usual Tuesday time slot, but I'm glad that you turned out today. We've got a really interesting program. As you may know, probably our signature research initiative at the program right now is Globalization, Lawyers in Emerging Economies, where we are studying in particular the evolution of the professional services sector, particularly the corporate legal services sector in India, Brazil, and China, and doing empirical research on the evolution of the legal professions in those countries. And we're planning to expand this to other emerging economies as well. We also have a number of other research initiatives looking at studying careers of lawyers and how they make transitions between jobs, how they make decisions, and ultimately what they find satisfying in their careers, and also what they find useful in their professional development as they move on. And finally, we write case studies, a body of case studies on the legal profession, what it means to be a legal professional, and be in that role, looking at really how decisions are made in a role like general counsel, for example. So I was particularly thrilled today that we've recruited a speaker who has the willingness and ability to speak to really all of these things in one, having been general counsel for Brazil, for Citigroup for many years, and now being at the law firm of Pinheiro Guimarães in São Paulo. So you can come here to hear me, so I'll hand you over to our speaker, Bill Meissner. Thanks.
Thanks very much, Eric. Good afternoon. It's always good to be in Boston in October, and it's especially a pleasure today to be at the Harvard Law School. By way of background, I was born in Boston and I was raised in Newton. And the real reason for my trip at this time is because Newton High School, from which I graduated in 1962, is having our 50th reunion over the weekend. I would also add that I have always been a Red Sox fan, and in spite of it all, I still am. I would also add that when I left Newton, I went directly to Yale, and unlike some of my colleagues at Yale, Yale really was my first choice. I wasn't sure if that was going to be picked up. I began my career in a New York law firm, and I've spent most of my career living in Brazil. I'm admitted in Brazil and admitted in New York as well. And currently I'm a partner, as Eric said, in the São Paulo office of the Brazilian law firm of Pinheiro Guimarães Advogados. I'm going to speak about the function of general counsel for an American company in its operations abroad, specifically an American banking group operating in Brazil. By way of background, just quickly, I think you all know that Brazil is a large country. The economy is growing rapidly. It's certainly emerging, if not already emerged. It's one of the BRICS. It occupies about half of the landmass of South America. It has 200 million people, close to that. And I think the GDP of Brazil is around the 8th largest in the world. I see somebody nodding, so that's a good sign. And I'd like to tell you a bit about a bank as well. When I was in law school, I knew that the bank had tellers and that there was somebody who sat by the safe deposit box, but that was really about all I knew. And I didn't learn about the inner workings of a bank until I actually began working with a bank, inside a bank. I want to give you just a brief outline as to how, in my mind, in any event, this is not from a textbook, how a bank is organized, so I can put the legal function into some perspective. A bank basically has businesses and staff. Maybe this is old hat to all of you, but I didn't learn this until I joined the bank. The businesses are in the business of making money, and they all do. They make money. That's what they're supposed to do. They incur expenses, but they bring money into the bank. That could be trade finance, it could be lending, it could be securities custodian services, it could be anything that banks engage in, leasing and so forth. The staff functions do not make money. And quite honestly, the staff functions inside a bank are never quite as glorified positions as are the business functions because they don't make money. Staff functions would include, obviously, legal. It would include operations, human resources, accounting policy, risk management, which used to be called the credit department, and today it's much broader because there are many more risks that have been defined and that the bank has to be concerned about. Your compliance function would be a staff function as well. Within the staff functions, you have, in my mind, in any event, basically 4 functions which you would call control functions. Control in that they look at what the businesses do. They may say, don't do that, or we'll work out a better way to do it, or you should follow these rules and so forth, or you should face these risks and analyze them much better. The control functions would certainly be legal. It would also be the compliance function. Compliance is a function that grew up in the 1990s and basically is a group of people that know what the rules are and try to make sure that the bank complies with rules. A lot of it's focused on money laundering, and a lot of it is really operational more than legal or accounting. So you have the legal function, the compliance function, the risk management function is definitely control, and the finance function usually is a control function as well. Sometimes the finance people are highly encouraged by the businesses to help figure out ways to make money, and on other occasions they are closely allied with the control functions. In light of all this, in any bank, and I think this is safe to say, in any bank at any given time, you will have creative tensions. Very positive, but they're creative tensions. Working in a bank is not like working in an organic food store. It gets stressful. And the tensions that you would find would be one business with another. Supposing you launch a new product. Which is the business that's going to get the credit for the product? The income comes into the bank. Who gets registered? Who gets the income registered in his or her area? So between the businesses, you have a creative tension. Businesses and controls. Obviously, you have a creative tension there. If a business wants to launch a new product, the business has to come to the control functions and get their opinion, try to convince them that it makes sense, and so forth. You will also have tension between, with a bank like Citigroup, tension between the head office and the local bank. The head office may want to do certain businesses which in Brazil, for example, may not make sense under the regulations in effect. You will also have conflicts between U.S. laws and regulations and the local laws and regulations. Banking, obviously, is a very heavily regulated industry everywhere in the world, and the banking regulators in a place like Brazil take it very seriously. I think they're considered world-class. My experience was always excellent with them, and obviously in the United States there are several regulators that are monitoring what the banks do. Sometimes you may have a conflict or a question that you've got to help work out between the two regulatory authorities. I'm going to talk to you about 2 cases, and the purpose is to give you 2 examples of what I faced in sitting as general counsel for Citigroup, and the problems that they presented and how we worked them through. They're not run-of-the-mill types of problems that you would find working in a bank in the States, but they are the kind of problems that I think any general counsel working for the operations of an American company abroad would be likely to come up against. The first case I'd like to talk about, I will give you in general terms, it's a case where the business demands went way ahead of the local regulations. Specifically, and try to make this as simple as possible, the question was, what can a Brazilian bank or what can a foreign bank do with Brazilian residents in terms of helping them open a bank account abroad? Well, that doesn't sound very exciting, I'm sure. But until the 1990s, early 1990s, it was never clear exactly in Brazil whether somebody could have a foreign bank account, under what circumstances, how they could put money in the foreign bank account. Foreign exchange was very highly controlled in Brazil for years, to such a point that in the 70s and perhaps the 80s, I remember this from personal experience, one could not travel abroad and buy more than $1,000 for a trip. Exchange was very, very tightly controlled, and it was controlled through the banks. All exchange transactions had to take place through the banks. In 1992, the central bank passed some regulations which were really forward-looking, and it took probably much of the decade for those regulations to be understood and fully utilized by the financial institutions. Basically, the central bank said anybody who wants to send money abroad can send money abroad so long as they prove the origin and they prove that they've paid taxes on the funds that they're sending abroad. They could buy US dollars and remit them abroad. This was a big opening of the foreign exchange window for Brazilian citizens. And if they could do that, it was obvious that they had to send the money someplace so they could have a bank account abroad. There was nothing wrong with that. The regulations didn't say that, but obviously that's what they meant. If you can send money abroad, you can have a bank account abroad. This was really revolutionary, and any foreign bank that knew about the opening up in Brazil of the foreign exchange would think about the possibility of getting Brazilian customers. And certainly Brazilian banks thought about what can we do with our local customers so that they can open up accounts abroad. And this is a case where there were no regulations, no laws, nothing specifically in point in Brazil. And it was with a backdrop that there were certain broad regulations that even had criminal implications if someone were to violate exchange operations or restrictions on banking activities. For example, it was a crime, excuse me, and it still is, for a foreigner to go to Brazil and engage in the business of banking without due authorization. Well, is going to Brazil and opening an account in Brazil for a Brazilian citizen doing banking? Nobody knew, but arguably it is, because people who open bank accounts tend to be banks. Another problem with the regulations was that the Brazilian banks themselves were not authorized to open accounts abroad or to sell securities abroad to Brazilian customers, to do anything that would cause the Brazilian customer to remit funds abroad or to engage in a transaction outside Brazil. It wasn't clear that that meant that the Brazilian banks could not do that, but it would be quite daring for a Brazilian bank to engage in basically doing banking abroad, locally in Brazil, with this backdrop. Then there were the exchange norms that basically said that banks had to be assiduous in protecting Brazil's reserves. Well, would encouraging somebody to send money abroad to a foreign bank be protecting Brazil's reserves? Maybe not, but it wasn't clear what that meant. And then there was a general prohibition against promoting the outflow of capital from Brazil, and nobody quite knew what that meant. In Brazil, we had an additional problem, excuse me, and that was the franchise risk. Franchise risk is a risk that something might happen to your local business that would adversely affect that business. For example, if somebody, in this case from the United States, went down to Brazil and did something that the central bank didn't like, the central bank isn't going to call New York. The central bank is going to call the president of the bank in Brazil. And if anybody has to take the hit, it's going to be the Brazilian operations. So we had a franchise risk in Brazil, but they did not have a franchise risk in the States. That doesn't mean that there weren't people in New York who were sensitive to the franchise risk. It's just that it's the difference between the commitment and involvement. When you have your breakfast with bacon and eggs, the chicken is involved, but the pig is committed. Well, we were committed in Brazil. When I was in New York from 95 to 2000 as regional Latin American head for the legal department. And I went back in 2000, back to the position of general counsel for the bank, and I was surprised to find that many lawyers in the department were receiving phone calls on a daily basis from the businesses asking things like, can we open an account for a widow who's 89 years old and has a net worth of $100,000? Well, there are no rules. There's no guidance, so they ended up calling the legal department. Or could we open an account for a person with a check drawn on J.P. Morgan in New York? Or endorsed, so forth. And these questions came in on a regular basis. They took time from the legal staff, and that in and of itself was not acceptable in terms of managing the legal function. And that, together with a serious concern that we all had, and the president of the bank in Brazil understood the concern, was very helpful, and our regional counsel, who was excellent Chilean lawyer with a Harvard law degree, so you can imagine how good he was very helpful in developing a business program with the legal department in Brazil. Legal department worked as well with the businesses, convinced the businesses that it would be better to have rules that they could understand and that they could work with, rather than to have to call the legal department every day, not to know whether these broad Brazilian norms applied or didn't apply to the activities that we were trying to engage in. We did up a business program with a thorough, I think it was thorough, analysis of the various risks involved. We pinpointed them all, and we discussed why what we were proposing to do would mitigate these risks to a point where it would make sense for the business to go ahead. We put in a list of do's and don'ts, or what they call rules of engagement. These are internal rules. They're not Brazilian laws or regulations. They're internal rules within the bank itself, and they said things like, obviously, don't open an account for an 89-year-old widow with $100,000 in net worth. But it had a number of other do's and don'ts that were based on two provisions in Brazilian law that we thought were, although not applicable directly, they were very relevant because by analogy. The first was, excuse me, the tax norms. We looked at the doing business rules for taxation. Doing business rules are basically rules that say at some point somebody who comes into this country is doing business here, and we're going to tax that person. If they don't go that far, we won't tax them. And the doing business rules in Brazil basically said that a transaction is subject to taxation in Brazil if it's closed in Brazil, if it's if the two sides become committed in Brazil. And the classic case was somebody coming down from Chicago selling plows in the interior of Brazil to the farmers, and they sign contracts in the interior of Brazil. The salesman goes back and gets the plow online for production. The Brazilian figures out a way how he's going to pay for it, and away they go. But that's actually closing the deal in Brazil. And in that case, the Brazilian tax authorities imposed a tax. Well, our case wasn't tax-driven, but it seemed to make sense that if somebody coming down from the States, talking to a Brazilian customer about opening a bank account, did not open the bank account, did not say that the bank account would be open, did not commit the bank, but rather said, this is what we have for accounts, look these over, I can't make a decision, the decision has to be made abroad, I'll put you in touch with so-and-so in Miami or New York, and the contact would be made directly with the bank abroad. The second set of norms, actually it wasn't even a set, it's a very short norm of the central bank, a resolution, that sets down the rules for a representative office. What is a representative office? A representative office is an office in Brazil of a financial group, foreign financial group, that is very low profile. It may be set up as a test to see if they really want to open up a subsidiary or a branch in Brazil. It may be set up to accompany a project that the bank may be investing in. But there are two parts to this regulation. One is that the representative office can visit clients of the head office. They can discuss all the products of the head office. They can give them information. And they can tell the head office what they've been doing, what they've visited clients. Clients are interested in this, that, and the other thing. But they can't engage in the business of banking. Well, it's almost self-serving, but we took that as an analogous regulation to what we were trying to do and said that the bank in Brazil is both a subsidiary and a branch. So it's at least a representative office, because a representative office can't do anything that the branch and the subsidiary can do. So if the branch and the subsidiary can do whatever a rep office can do, because they can't engage in banking, then as long as the local bank doesn't close a transaction, doesn't open an account, doesn't commit the bank to something, commit the bank abroad to something, then they're not engaging in the business of banking. Now, these are arguments. These are not clear. The central bank could come along and say they don't agree with it and so forth. But we were satisfied that these rules were analogous and they would limit the activities of the bankers, both the foreign bankers and the Brazilian bankers, to such a point that we thought the risks were acceptable. The business program had training provisions. It was quite a big document. And we ended up with that. The business, curiously enough, flourished after we did the business program. Why? Because they didn't have to call every day on every possibility that could come up as to what they could do. You think of it this way. Suppose there were 100 things that they could do, and they didn't know if any of them were legal. So they called the legal department every time they wanted to do something. Well, if instead of 100 things, you reduce it to say, you can't do 78, but you can do 22. Well, all of a sudden, they're free to do 22 things without calling the legal department, do it as much as they want, or within the limits that we've established. And it was clear for them, so they could take the ball and run with it. It was really very positive for the business. Excuse me. We called it a referral model, and the region was very helpful to us in developing it, and they took it even further and have since followed a referral model for the rest of Latin America. That is, whatever you discuss with the Brazilian customer, and today it would include not just opening an account, but buying a security abroad or whatever. You may discuss the product and so forth, but you have to refer the person abroad. So the transaction is closed abroad. We worked very closely with local counsel in Brazil, who was very supportive of this, a very good friend. And I understand that they have suggested the model, at least to other financial institutions in Brazil. The final point I would make is that with all of these rules, risk analysis, and so forth inside a single document with training, that's very important, the training you have to bring in human resources. If the authorities come in and say that they don't like something that you're doing, you can show them that you've thought about everything. And if for some reason you didn't quite get it right, supposing you set the limit excuse me, on opening accounts at minimum of $25,000, and the central bank says, no, that's not enough, it should be 50. All right, you change it to 50. But at least they would see that we thought about it and we reached a decision, a reasoned decision with which we thought we could live. And if you don't have something written to show the central bank, then they don't know where you're coming from. So that was a big help. And the final point is, if you have something written, especially with relationship officers, and especially in what we call the consumer bank, these people have goals. And of course, they're supposed to meet their goals within the rules. And if they don't meet their goals, they may suffer consequences. So sometimes there's pressure, perhaps too much pressure to meet goals, and an account officer may do some things that it shouldn't do, he or she shouldn't do. Suppose the central bank comes along and said, look at this, your bank is doing this. If you have everything written, your risk analysis, your product program, your rules of engagement and so forth, you can say to the central bank, no, that's not what the bank does. That's what this person did. The person will be disciplined, but that's not what we do. And that's a very strong position to take with the possibility of administrative sanctions. So with that, I'm going to move on to a second example, excuse me, which is shorter. This is one example. I tried out this speech on the young lawyers in my law firm, and they're Brazilian lawyers, and they had a little trouble understanding this. So I've tried to make it simpler. It has to do with import financing by foreign banks. But at the end of the day, I think you'll see this pretty clearly. What it really has to do with is a piece of legislation that was an aberration. It was just wrong. A Supreme Court decision that was just wrong. And this all affected foreign banks, all foreign banks that financed imports to Brazil. And how do you come out? How do you explain? How do you give a position to somebody abroad when you have a law that doesn't make sense and a Supreme Court decision that doesn't make sense? I don't mean to be depreciative of the Brazilian legislative process or the Supreme Court by any means, but this was back in 1968, 1972, when the military government was in power. The legislature was not functioning, and quite honestly, it wasn't the high point of the rule of law and separation of powers in Brazil. When a foreign bank finances anybody in Brazil, the foreign bank makes the loan. This would be to companies for a project or for whatever, working capital. And the Brazilian borrower pays in hard currency, very tightly controlled through the banking system, both the principal and interest on the loan. The interest is income to the foreign bank. And the Brazilian government said that any interest paid to foreign banks in foreign financings, as a rule, is subject to taxation in Brazil. How do you tax a foreign bank who's received the income in New York, say, how do you tax that person in Brazil? You withhold the tax. And the party who withholds the tax is the Brazilian borrower. And at the time I'm talking about, it was 25%, so the Brazilian borrower would make an interest payment of 100, take 25, pay to the Brazilian government, and send 75 abroad. For those of you who know how this works in Brazil, you'll think I'm oversimplifying, which I am, but that's roughly what happens. As has been explained to me, and nobody's ever told me otherwise, in 1968, Brazil engaged in a huge hydroelectric project called the Itaipu project with the Paraguayan government. And it was the government itself that engaged in the project. And obviously, for a huge hydroelectric project, they were going to import an awful lot of equipment and machinery. And they passed a law in 1968 with one provision which said that there is withholding tax on foreign financings for importation into Brazil, and the taxpayer is the Brazilian importer. This contradicts the Brazilian tax code, which says that the taxpayer is whoever receives income. And there's no way that the Brazilian importer receives income. Consequently, there's no way that the Brazilian importer could be the taxpayer, but that's what the law says. And if the Brazilian importer is the taxpayer, for the Itaipu project, the importer was the government. The government doesn't pay taxes. Therefore, there was no tax. So it reduced the financing costs of Itaipu for imported machinery by 25%, which is a big savings. In those days, the interest rates were 20% a year, 18% a year. They were sky high. So this was a big help to the Brazilian government. Usually, the Brazilian government is not an importer. If the Brazilian government engages in a project, it will do it through a company in which the government participates or whatever, and they'll pay taxes. But in this case, it was just the government. In the case of other Brazilian borrowers, with that provision in place, the Brazilian borrowers would pay the tax because they weren't the government, and they would send the receipts abroad, and the foreign bank would take these receipts and get a tax credit with the IRS in the States or wherever, whatever jurisdiction it might be. And that's the way it works. That's the way it worked after Itaipu and so forth. The law was challenged as being unconstitutional. In 1972, the Supreme Court gave a 5-4 decision ruling that the law was constitutional. And it's an amazing read if you ever get a copy of it. The 4 justices who voted that the law was unconstitutional wrote very quick opinions, basically saying there's no way you could possibly believe that this law is constitutional because the Brazilian borrower is simply not the taxpayer, and calling him the taxpayer doesn't make him the taxpayer. And one of the 5 justices who voted in favor suggested that it would be appropriate to change the language to adjust it to the Brazilian tax code, which means that it would be appropriate to call the taxpayer the foreign bank or the recipient of the interest income. In any event, these were curious decisions. And at the end of the day, nobody really is going to challenge the law, which is still on the books. Nobody's really going to challenge it. The Brazilian government doesn't care if a bank takes tax credits abroad or not. The Brazilian government just cares that the Brazilian importer, when it's not the government, does pay the tax over to the tax authorities. The Brazilian importer doesn't really care because one way or the other, the Brazilian importer is going to bear the cost of the increase from the taxation. We had a request from head office to make a determination, a final determination as to whether we should continue to take tax credits or not, which begs the question. It's whether we can convince the IRS that we should take tax credits in this case. And the question is, how could we be taking tax credits when the law says we're not the taxpayer? That's a curious thing. We sat down with the tax department and we wrote a memo to the head office jointly, and we just decided that we tried to justify it in legal terms long enough, and it wasn't adequate, so we threw away the idea of a legal memo with legal conclusions. So our memo said, first, disregard that law. Doesn't exist. Second, disregard the Supreme Court decision. The law and the Supreme Court decision worked very well for the government. It doesn't hurt anybody else, but don't think that it applies to you, frankly. Further point we made, we do not believe that any Brazilian tax authority, if questioned on this, would say that the foreign bank was not justified in taking the tax credit, or that the foreign bank was not in fact the taxpayer. We got, in addition, reputable local tax counsel to confirm our reasoning for the head office, and we sent it up. And I checked before I came up, and indeed, the bank continues to take tax credits in its foreign financings of Brazilian imports, as I think all banks do in general. I think what you draw from this is that sometimes a strict reading of the law and legal events, in this case a law and the Supreme Court decision, may at times not be adequate to help you reach a decision as to how you should be acting. Sometimes the economic and the political realities are as important as the law. And I don't think that's just my experience in Brazil by a long shot. I think you even find that in the United States. And the final point, as I made at the beginning, is I don't believe today that you would find legislation of this nature ever being passed, and I don't think the Supreme Court would ever reach a decision like that. Those are the 2 cases I wanted to mention. I think they're not something you would run up against if you were general counsel in the United States, and I think they're illustrative of some of the problems we face in managing the legal function of a U.S. bank abroad. Yes, I haven't been general counsel for U.S. law for any company to be able to compare that with my own experience. I was in the United States with the bank in New York, excuse me, as a regional counsel. The differences, I think, if you're general counsel for the activities in some country abroad, you basically are subservient to head office, subservient to the general counsel in the head office, subservient to U.S. laws and regulations, but at the same time, you have to be vigilant as to the compliance with local laws and regulations, which sometimes conflict. And not once in a blue moon. They conflict a good deal. And you get caught up in a question of allegiances. Should you be most loyal to the business in Brazil? Should you be most loyal to the laws and regulations in Brazil? Should you be most loyal to or more loyal to the head office and what the head office dictates? To what extent should you say to the head office, I understand what you're saying, but I don't think it's going to work here in Brazil? And it's not infrequent that we get statements from people in the States, not everybody, but more than one, with an expression like, I don't care what Brazilian law says, you're going to do this, this, and this. And there, that's hard to work with. You can try to go over their head to somebody higher up, which is never a good thing to do. But you encounter that sort of thing, and sometimes it gets very frustrating. I could give you some examples afterwards if you have a minute, but I won't go into it because it'll take up the rest of the time. But I think the differences really are you've got local laws and regulations, and that's what you're supposed to be watching out for. But you have local U.S. laws and regulations that somebody's going to tell you you have to follow as well. And sometimes that's a balancing act. It's fun, though. Oh, you take in all sorts of factors. And depending on any given time in the life of a bank, for example, after 2008, the control functions could just walk in and go grrr, and everybody got scared because the business had failed. And on other occasions, the businesses are soaring, and you go in and you try to control them, and they walk all over you. I'm exaggerating, but it depends on a number of factors. And in the case of the account opening, for example, I think we were opening accounts at some point with not very much money, 10, 15,000, and then the clients discovered that if you didn't have at least 25,000 in your account, you'd have to pay a $30 fee every month. And then the clients didn't like that, of course, and they decided they wanted to close the account, in which case the exchange rate had gone down, so the amount that they'd bring back was not very much. And we realized that you had to worry about this sort of stuff. Was it suitable for these people to open up an account? Probably not. If they couldn't keep at least enough so that there wouldn't be a fee, didn't make any sense. So I think you have to play it by ear and use common sense to the extent you have something like that, a track record to look at and say, gee, we had a bad experience here. Let's be extremely careful on this point. And each bank will have its own horror stories to tell, but the horror stories always give you a good idea about where you should be creating limits. Foreign Corrupt Practices Act is not a difficult thing to comply with or to verify compliance with. In Citibank's case, there was somebody in New York who was the champion of the FCPA. There was somebody at the regional level in Mexico, somebody at the regional level in Miami, and everybody tried to get involved. Compliance, who wasn't in, it was a different department, legal, and so forth. And very heavy training on the FCPA. Sometimes this is a curious example. The bank at one point, and I think this is common in banks generally, they want to get some commitment or some evidence that they've checked to make sure there's no problem with the FCPA. And the bank asked to have a letter signed up by all of our outside counsel with whom I related. Obviously, these were people I would have to contact, and have them sign a letter saying that they have not been bribing government officials on our behalf and that they would not bribe government officials on our behalf and so forth, which is a terribly offensive thing to ask anybody to do. And you know, if they were or they weren't, I mean, I'm satisfied they weren't, but if they were or they weren't and they signed the letter, what difference does it make? And we took the letter and we revised it substantially, and we basically said, you are rendering services and have a strong position of confidence with our institution. We kindly ask that you be extremely vigilant to make sure that the law, the translation of which is attached here too, is complied with by the bank, and if you see anybody from the bank or any of its service providers doing anything that you think could be in violation of the law, we count on your good offices to advise us as to blah, blah, blah. And they signed that, and that ended up being okay. It wasn't offensive. At least nobody complained about signing that. So we are very careful on the Foreign Corrupt Practices Act. And Brazil has its own Foreign Corrupt Practices Act. And frankly, anything in the Foreign Corrupt Practices Act that's illegal is illegal under local laws in most jurisdictions as well. I got excited about Brazil when I was in college. I majored in Latin American studies, and I'd done almost all my language work in Spanish, and I didn't want to have to take Portuguese, but they said we had to take Portuguese. 1 year of intensive Portuguese, and I fell in love with the language. It was a time when Bossa Nova was beginning in the United States, and I bought the João Gilberto records and memorized the words because his diction is better than Frank Sinatra's. Many Brazilians learned English memorizing Frank Sinatra songs. And then I had a summer between my junior and senior year in Brazil, in Rio de Janeiro, and a 21-year-old person from Boston going to Rio de Janeiro, it opens your eyes. I really loved the place, and I found it so. Nobody felt guilty about anything. It was just marvelous. And then I had a Fulbright to Brazil between college and law school, and I traveled all around the country. And somebody told me the reason they gave Fulbrights was so people would get hooked, and it worked in my case. I came back, went to law school, worked in New York, and my wife, Brazilian, said, it's time to go back. So I said, yes, dear, and we went back. Actually, I went back with Citibank in '72 to work in underwriting. The securities markets were just taking off, and nobody knew what a U.S. bank could do with securities in a foreign country. They couldn't in those days do much in the States. I don't know today, I think they can do a little more. But I don't even think Regulation K, which is the Federal Reserve regulation governing the activities of U.S. banks abroad, I don't even think that was in effect at the time. And I went down and the stock markets collapsed. I ended up drafting dollar loan agreements inside the bank, and I figured at a point I could do that and more and not run the risk of being a banker, but staying a lawyer. So I went into to private practice with a law firm in Brazil and concluded fairly soon that I really should pass the bar if that was going to be my career. And I did what they call revalidating your law degree. I had to get a local law school to see what I'd studied and so forth and determine what I had to do to complete it and make it adequate in Brazil. And basically it meant taking a test in each one of the major areas of law. It's not that different, really. I mean, once you've studied real estate, you know that there's going to be a real estate registry someplace. I didn't know that until I went to law school in the States. But when I studied in Brazil, I knew that there had to be a real estate registry. And companies, corporations, shares, you know what that stuff is after law school here. So it wasn't all that difficult to revalidate the diploma. Then I had to take the bar exam. And I wasn't happy about that, but in retrospect, it was a tremendous experience. I took the civil code and went article by article with a dictionary and a great treatise writer next to me, and then I did the same with the Code of Civil Procedure and took the bar exam. Basically, managing the legal department in Citi today is, I think, over 90 people, 90 lawyers, and you have to manage the personnel, you have to learn what a budget is, you have to prepare a budget for the next year, figure out how to do head count, learn some of the tricks of the trade, like if you think you can do without some of the lawyers, don't fire them until they ask you to. Because if you fire them and they'll say, oh, that was great, don't worry, we won't ask you to do it again, they will ask you to do it again. A number of things which really you don't learn in law school, and I never learned practicing law in a law firm. But the whole administrative aspect, and sometimes that can be difficult. I remember last year I was there and I had to go into a special program to approve 28 reais expense, which is like $14 expense. I thought, I don't want to do this. It's crazy. But you have to do that kind of stuff. So there's that. Then you have responsibilities for managing litigation. We outsourced all the litigation. But and we had like 40,000 cases pending against Citibank at any one time, which was a small number compared to other banks. I think Banco do Brasil had over 1 million, or has over 1 million. And no, but a lot of them are little consumer cases. But managing litigation was a tremendous job, and I think maybe 35% of the legal department staff is there not to do litigation, just to manage the litigation. So that's a major part of the a major responsibility as well. Then you do corporate secretary work, you sit on various committees, and of course nobody knows the answer, they expect you to have it, which that's fun. Local banks tend to have legal staff that actually does litigation. Foreign banks don't. The local banks don't have to worry about the U.S. regulators coming down and doing examinations on the banks locally. They don't have to worry about the eventual conflicts between the regulators. And they don't have to comply with U.S. laws, which from time to time makes a big difference. I remember when the Real plan went into effect, that was a new currency. All the banks had their mutual funds set up so that there was one mutual fund that provided cash to all the others. And in the transition between the old Cruzeiro and the Real, the banks didn't have enough reais in cash, so the mutual funds didn't, so they had to borrow from their banks. Well, a mutual fund managed by Citigroup can't borrow. It can only borrow from Citigroup if it's 100% collateralized in New York. And it's extremely expensive, and you don't even want to ask New York if you can do that. But we didn't have any choice, because we, as a Brazilian bank, we could have lent the money to the funds, but as a U.S. bank, a mutual fund managed by the U.S. bank is considered to be a company of such an affiliation that you can't transact business with it. Yes, I don't think there was any difference. I can think of one Brazilian bank where the head of the legal department was considered very highly, more highly than I was considered. And it depends in large part on the size of the operations and so forth. As a general rule, I think the quality of general counsel in Brazilian banks is extremely good. There's one case, an example of a fellow who was general counsel for the Banco do Brasil is now a justice on the Superior Court of Justice, and he's just excellent. He's one of the best justices that I think they have. And I'm sure he was an excellent general counsel, brilliant. And the Brazilian banks, frankly, they have to deal with foreign banks, and they have their own foreign banks abroad. They have branches in the States, in Europe. They have operations all through South America, some of them. So they aren't, it's not like, I don't know, Argentina or a place like that where the banks would just be local banks and the biggest bank would pretty much just be a local bank. In Brazil, the Brazilian banks are multinational banks, the big ones. You don't work for the Brazilian antitrust regulation? Oh, did you? Oh, okay. Yes, we faced the issue. We faced the issue. In fact, that was one memo. I remember we did that for the head office. It was most fun. The central bank, just background for the central bank traditionally has said, we are in charge of the banking system, and we will authorize everything that needs authorization, including mergers, acquisitions, and so forth. And then you have the antitrust agency, which I think dates back to the 60s or something. They became more and more powerful, and they said, no, no, no. We have to look at the antitrust implications of mergers and acquisitions. And the central bank said, no, you don't. And they said, yes, we do. And they finally got an opinion from the Office of the Government Attorney's Office, saying that it was exclusively in the hands of the central bank to determine whether there were any antitrust implications for a merger and acquisition, in addition to looking at the question of the safety and soundness of the transaction in and of itself. And the antitrust agency said, well, but of course the opinion of the governor, the government attorney's office doesn't apply to us because we're indirect. Something, I forget what it was. You guys gave them all the information they asked for until they gave the opinion. Then they gave the opinion. We don't really care that much. I can tell you quite honestly where the risks are. If a bank hasn't been going to the antitrust agency and all of a sudden it goes to the antitrust agency, the CAGI, the antitrust agency, asks for the last, 5 transactions that you've done. And if you haven't reported those 5 transactions to CAGI, who knows what's going to happen? So banks that have not gone to CAGI yet are reluctant to go to CAGI, to the antitrust agency. And I think it's clearly changing, and I think it's reaching a point where many major banks have changed their minds and actually gone to CAGI with their problems. It's, I don't know where Citibank stands on it now, and they haven't done an acquisition that I know of for some time to see if they've changed their minds yet. But they will if they haven't already. I think it's clear that both CAGI and the central bank are going to end up looking at any acquisition in the financial sector. Several views. First, well, when working inside Citibank, well, let me just, for those who don't know, that in Sao Paulo you've got just about every significant law office from London and New York with people in Brazil. Now, what they do varies substantially. Some of them are very low-key. They only really do New York law, I think it's safe to say. They may have one Brazilian or two working there, but they don't do Brazilian law. Others have actually merged, even though they try to pretend they haven't. They've merged with in fact, you guys ought to go after these law firms. They've merged with local law firms, and they try to practice Brazilian law and New York law at the same time. And that's very dangerous, I think. I remember one case where we got an opinion from a local law firm, and it had the name of a major U.S. law firm on the letterhead with it. And it couldn't have been the U.S. law firm. It was a Brazilian legal opinion. And it had no business having a U.S. law firm name on it. And you wonder the judgment that goes into this. So frankly, that arrangement has since been undone. And several have been undone. From the position of general counsel, I was always glad on a cross-border transaction to have our foreign counsel with somebody locally. I could call him Saturday night. I could go over and see him. I may be old-fashioned, but I much prefer the personal contact than doing things totally by phone or email. I think there's room for the foreign lawyers in Brazil. I think Brazil's benefits from their presence, and I think they will over the next 10 years when you're going to have hundreds of billions of dollars coming in to finance the Olympics and the World Cup and the pre-salt petroleum prospection and so forth. And I think it makes sense. But at the same time, I think that the Brazilian bar is absolutely correct in opposing a merger between a foreign firm and a local firm. I remember in one case, a very dear friend of mine was from a firm which basically merged, and I said, you know, we'd love to use you, but I don't want to use your local people. And he said, well, let me introduce you to them. I said, I don't want to meet them. We have our local counsel, and we want to be able to choose. And I think that's the important point, is anybody who is doing something cross-border is going to have to engage counsel abroad, fine. But they want to be able to choose who they're going to use locally. I mean, they don't want to have somebody impose it unless they don't know anybody. So I think there's room for the foreign counsel. I think there's no room for mergers as such, certainly not at this point. But they do help when you have a cross-border transaction and you're working in Brazil. Well, thank you very much, Sidney.